Meenakshi Natarajan's case has been peculiar. Her nomination was rejected, Supreme Court decided not to intervene, but she still has the option to look at what High Court is going to say in Madhya Pradesh. But the question here is, if the case was not in cognizance by the court, why her nomination was rejected? This might create confusion and needs clarity. So we will be doing exactly that today. Hello everyone, welcome to Vajiram and Ravi's Flash News. My name is Shubhangi Singh, and in today's session we are not just going to talk about Meenakshi Natarajan's case, we are going to understand the important process when we are talking about filing for nomination, what was missing in her case, and what will be the clarity that this particular case might bring in. So let us begin with understanding that what exactly happened in this case. So basically, Congress leader Meenakshi Natarajan, she was the one who had a Rajya Sabha nomination, and she was filling that Rajya Sabha nomination from Madhya Pradesh. Now, before I move into more detail, let's talk about Rajya Sabha, the elder house of the parliament. Now, at max, the seats are allowed at 250, and in this, 230 seats are coming from states, 12 are nominated by the president. They come from fields of arts, science, literature, and social services. Now, how many seats the state will get in Rajya Sabha is dependent on the population of the state or union territory. Now, in this context, when we are looking at this nomination was coming from Madhya Pradesh. And when Meenakshi Natarajan filed her nomination, the returning officer who was taking her nomination said that she did not disclose a criminal complaint which is pending against her in Hyderabad. And because she did not disclose that, her nomination becomes invalid. For the very same reason, Meenakshi Natarajan approached Supreme Court. Supreme Court said, we won't intervene at this stage. If they want to pursue this, they can pursue it through election petition. Maybe later when this is brought up to Supreme Court, that route can be considered. In this context, this case is very important for understanding that what kind of disclosure and what time needs to be made by people who are filing in their nomination. This case will also give an insight that how do we define the powers of returning officers and where do we draw the line between the electoral transparency that need to be maintained who are fighting the elections and what is the legal fairness that they should be getting and voters also need to get. Now that we have understood the basic overview, let us move to understand that when we are talking about this case, what exactly unfolded? What was the timeline for it? So initially, now when we are talking about this case, let us understand that what was the timeline of the criminal case that we are talking about, the criminal complaint in Hyderabad. So complaint was filed in Hyderabad against Meenakshi Natarajan. In this context, pre-cognizance summons were issued. What do I mean by pre-cognizance? That simply the court has not registered the case. If I have to give you brief, they have not registered it. After that case, once it is registered, it is mentioned in the affidavit. So as of now, only pre-cognizance summons were given. The case was not present in the affidavit, and that is when the nomination scrutiny happened. And because of this very thing, the nomination was rejected and Supreme Court was approached. Supreme Court said that election petition remedy should be gone for, not directly approaching Supreme Court. Now candidate is saying because it was at the pre-cognizance stage, that's why we did not mention and there is no legal obligation to do so. And returning officer is saying that every pending criminal case should be disclosed. So that means returning officer has one side to it and candidate has another side which is being quoted as legal side as well. So what is exactly right here? So to understand that, first let us throw some light on the cognizance part. As I mentioned, what do we mean by cognizance? This is the time when court formally takes notice of the offence and they decide they will be moving on to this case judiciously. If we are looking at criminal proceeding, it starts with complaint being filed, then pre-cognizance, that means court has not registered the case, the proceedings have not started judicially. After that, court takes the cognizance and then charges are framed and then trial begins. So if we are looking at that, the main question emerges out here is that if the candidate is fighting an election, do they have to disclose a pre-cognizance case also now? And where is the legal backing for it coming? So when we are looking into the legal framework, we have to consider two things here. The first one here is section 33A of RPA, that is Representation of People's Act of 1951. This talks about disclosure of the charges after they have been framed. This is a proper statutory provision. That means there is a law. This is an act. And if we are looking at the disclosure after the charges have been made, this is a narrow interpretation of what has been written in the Representations of People Act. Now when we are talking about section 33A, which comes from the Representation of People Act 1951, this says that the candidate needs to disclose any case in which he is criminally charged for and the punishment there is of more than 2 years. But the problem here is there is no clarity on where that case needs to be disclosed. Charges have not been made. There is no requirement based on this. If we are looking at the interpretation, no. If the pre-cognizance states, it is unclear, there is nothing. If the charges have been framed, then based on this, the disclosure needs to be made. This is a proper statutory provision and this only gives a narrow interpretation. But when we look at the Form 26, when we are talking about Form 26, it is basically an election affidavit that every candidate needs to submit who is contesting the election along with the nomination papers based on rules of election 1961. Now, this Form 26 talks about that when we are talking about disclosure, that needs to not only the pending charges but also which are in pre-cognizant states. And this is a proper election rules provision. This ensures transparency for the voters. Now the thing is, Meenakshi Natarajan Case is saying this is what is more bigger in terms of, because this is a proper legislation. But Form 26 is something that we cannot ignore, and this also is supported by previous judicial developments such as the PUCL case. Supreme Court gave the verdict that voters have the right to know, so narrow interpretations will not work. For example, Public Interest Foundation case 2018, that there is mandatory disclosure of any criminal antecedents. Satish UK case of 2019, cognizance taken case must also be disclosed, not just the ones where the judgment has been pronounced. So all of this gives a lot of weightage to Form 26 as well, where we should go for broader understanding of these legislation and more transparency towards the voters, because this disclosure ensures that there is a proper informed voting, democratic accountability, electoral transparency and ethical politics. And this becomes very important in the times when the criminalization of politics is at rise. If you look at the numbers, the percent of MPs in Lok Sabha with criminal cases was 43% in 2019. It is at record high of 46% at present. This shows that how these cases are serious, and these are the people making policies for us, deciding how the country will be running. So the clarity on this case will ensure that we have constitutional principles such as free and fair elections, right to information, democratic accountability also ensured, and this will bring more clarity to that. Now, what are your thoughts on this? Let me know in the comment section. That was all from my side. Thank you so much.